Well, everyone, thank you so much for joining me today. I'm Lynn St. Louis, and what we're going to be talking about today is everything you need to know about estate planning, which is kind of a big topic to cover. So as you can tell, I'm probably going to cover a lot of ground and not go through a lot of depth to do so. So I am going to be sharing my screen. You probably see it now. If you do, put in the chat so that I can tell that yes, you can see the screen. We are going to be using this to go through and talk about the estate planning documents that you need so that you know everything you need to know about estate planning. I'm saying that, and I'm kind of smiling while I'm saying that because obviously it's a big topic, but we are going to cover a lot of ground. You are going to come away with a ton of information today. And since you are joining me, we are going to be sending you this guide as well. So without wasting any more time, let's go ahead and get started. So we're going to be talking about estate planning. Now, one of the first questions everybody asks is this question: do I even need an estate plan? And if you've asked that question, you are not alone. A lot of people think, well, I don't need an estate plan. I don't have a big estate. I don't have, a this or that. And so let me, clear up any misconceptions. Everyone who is an adult needs an estate plan, even if you think you don't. Even if you think, for example, that you don't have, a lot of wealth or you don't own a house. If you're an adult, you need an estate plan. And the reason is this: if you don't put into a place your own estate plan and something happens to you, either disability or death, well, guess what? The state has its own estate plan for you. And I think a lot of people don't understand that. So an estate plan really is so that your own wishes, your own desires are going to be made known, and that will keep the court out of your business. It'll keep the state out of your business. Nobody wants anybody else speaking for us, but if somebody has to speak for us because of incapacity, we'd rather it be somebody we know, we trust, we've appointed, and not somebody who we've never met before that the court appoints as our guardian. So frankly, everybody needs an estate plan. So I'm not going to go word for word through all of this because you are going to be getting this. Again, if anything comes up, feel free to put it in the chat. I will answer the questions as we go because we're going to be covering a lot of ground, as I said. All right. Oh, one of the things I do want to point out that you'll be seeing in your guide about who needs an estate plan, everyone does, is that there are a lot of benefits that we can't talk about today because what we're going to be talking about is really what you need to know about estate planning. You, however, yourself might have questions like, well, what if I want to protect assets against long-term care, against nursing home? What if I have a disabled child? What about a special needs trust? There's so many individual situations and questions and answers, and those are not going to be, we're not going to dive deep into those today. However, like I said, if you have a particular question, I will answer it. We will be doing a follow-up where we go into more depth about situations that are very commonly asked questions about, wills with asset protection and that. There will be some information you'll be getting, but we're not going to cover it unless somebody asks it today. All right. So what are the estate planning documents that everyone needs? And when I say everyone, I mean you're 18 or older, if you have a kid who is 18 and going off to college. This is what everyone needs. So first thing, and in my opinion, it is the most important type of document that an estate plan must cover and should have in it, and that is your powers of attorney. Well, why is that? When you're alive, these documents are in effect. Unlike a will, that only comes into effect when you die. So when you are alive, you're thinking, well, I don't need any estate planning documents. I'm alive. Well, if you're alive and fine, you're probably right. But part of what we do with estate planning is trying to make sure that we've thought through the what ifs. What if something happens to me? What if something happens to your spouse? What if something happens to somebody you care about? Who is going to be able to speak for them and make decisions? And when I say what happens to the person, I mean, it could be a car accident, it could be a stroke, it could be maybe an older family member that has dementia. Things happen to people during our lifetime. And if that person is unable to speak for themselves, unable to manage their own affairs, these powers of attorney are what must be in place. So what we are going to start with is the general durable power of attorney. So let me focus on something right here. It says durable. What do we mean by durable? That's the critical piece. What it means is a durable power of attorney says that this document, this legal authority that you have given to somebody to speak for you, it stays in place even if something happens so that you can no longer make your own decisions. Well, remember what I said, why these documents are so important? They're important because if you can't speak for yourself, somebody else must be able to do so, because if you don't have it in place, then the court appoints somebody. The document has to say it is durable. Durable is what the law requires so that when you have appointed somebody to speak for you and you've lost capacity yourself, the document stays in effect and gives that trusted person the authority that they need to speak for you so that your wishes will be known and carried out. That's why durable is so important. So under a durable power of attorney, when I say general durable power of attorney, what we're really talking about is, your financial matters, your bank accounts, insurance claims, dealing with IRS, dealing with investments, dealing with the sale of a house, dealing with the sale of a car, anything that you could transact on your own that's really considered business is covered under a general durable power of attorney. Now, I've talked at other times about what specific authority must be in a general durable power of attorney. It's really important that if you're in a jurisdiction like Washington, or Idaho, where there's a Uniform Power of Attorney Act, that you specifically state certain things that are in the power of attorney. So for example, if you wanted to avoid probate, then what you need to do is make sure your general durable power of attorney has the necessary authority that says somebody can do non-probate transfers of assets, a transfer on death deed, for example. Or for example, maybe the life insurance needs to have a change on the beneficiary designation or the 401k or something like that. The general durable power of attorney must specifically state that authority. And if you don't do that, then the person will not have the ability to transact the business that you would want them to transact if you could speak for yourself. I really believe that the general durable power of attorney is the most important legal document that anybody can have because it protects you while you're alive. It makes sure your wishes will be carried out by a trusted individual and that the court will not be involved in your business. And one of the things that I want to mention, if you are married and if you think that you can transact business on behalf of your spouse and you don't have a general durable power of attorney, you're wrong. Why are you wrong? Well, you're understandably wrong. You're on the same bank account, so of course you can transact business, but you can't sell the house. You can't even call on a credit card and have somebody speak to you if your spouse is incapacitated and you don't have the general durable power of attorney. Especially for couples, you do not want your financial situation, yours and your spouse's, to be monitored by the court under a court order guardianship. All right. I spent a lot of time talking about general durable powers of attorney because I really feel strongly that they are overlooked and undervalued. If you take one takeaway from this, it's that the general durable power of attorney is critical to have. Let's talk about the healthcare power of attorney. Like it sounds, it is for healthcare. What that means is that if you're in the hospital and you can't speak for yourself because you're under anesthesia, for example, well, somebody has to speak for you. And if you've ever gone into the hospital and you had a surgery, you know that if you don't come in with your own healthcare power of attorney, the hospital will have you sign their own form, which it's good and it's bad. It's good because it gets you through the situation that they can speak to whomever you said, yeah, talk to my spouse, my husband, or my adult child. They'll be able to tell you what to do when I'm under anesthesia. So it gets you through that situation. But the reason I don't like it is that it kind of takes away the thought that, well, maybe I should actually have a true estate plan put in place, not just a form that the hospital had me sign so that they knew who to talk to, but something that really reflects my own wishes. So I do believe that having an attorney help you with your estate plan and not just the hospital give you a form would be a really advisable thing to do. So healthcare power of attorney is so that somebody can make medical decisions for you. And those medical decisions, as you can see from my screen, includes terminating life support. I mean, those are really serious things to think about. So it's really important that in advance of any crisis, that you have given thought to these types of situations and you have discussed it with the person who is going to be the person you've appointed as your attorney in fact. Under a healthcare power of attorney, they're also called a healthcare agent. Of course, they can access your medical records and do those others, anything that you could do when it comes to healthcare, including talking about your end of life wishes. So let's talk about that. What are your end of life wishes? So this is what's called an advance directive, healthcare directive. Sometimes you'll hear it called a living will, which is kind of confusing because it is not a will in any regard. It is, what do you want if you are deemed to be at end of life? So here's where you say, if the doctors have said there's not going to be any hope of medical treatment making you better, then withdraw life support, for example. This is very useful, especially in younger people, and you can bet that younger people rarely give the time and the thought to filling out a healthcare directive or powers of attorney. So if you do have a college age student and they're going off in the world and they're independent, maybe as the parent you want to talk with them about it. Maybe you don't. I mean, I know it's hard to talk about, and that's one reason that people kind of put their head in the sand and ignore estate planning, because nobody wants to think about these things. But maybe as a parent you do want to talk about things with your kids. Sometimes the easiest way to open the discussion is saying, hey, this is what my wishes are, and I kind of think yours would be the same, but am I right? What are your wishes? So that's what an advanced healthcare directive is. So what I'd like to move on to, and so this is kind of a transition here, we have talked about the most important living documents, the documents that are in effect while you are alive. Your powers of attorney for finances, for healthcare, and then your healthcare directive. So next we are going to move to, all right, well, what are the important estate planning documents that everybody needs to know about? Well, you definitely have heard of a will. I think everybody has heard of a will. In the information that I'm going to be sending to you, we're going to be talking not just about a will, but a will with asset protection. So we're not going to dig too deep into that today. So let's just cover what a will is. This is everything you need to know. So what is a will? Well, as you probably know, a will is what takes effect on your death. It says who your family is. It says who gets your assets, and it indicates in what proportion. So that is what a will does. Every estate plan, no matter what it is going to have a will. Virtually every estate plan. So what that means is that, let's say you have a different kind of document that's called a revocable living trust. That is also going to have a will. You know, any kind of estate planning platform that you have, and we will be talking about revocable living trust in a minute. Thank you for getting the glare out of my eyes. I appreciate it. Will have a will. So what do people not understand about wills? What they don't understand is that if your estate plan is set up with a will and there's no other plans in place for what happens when you die, there will be a probate. And everybody, no matter who says a probate, I don't want a probate. I thought a will meant that I avoid a probate. No, it does not. It depends. It depends on what your situation is. What did your attorney set up for you? Or did you do it online yourself? If you did, you've set yourself up for a probate. Frankly, the only way that you can avoid a probate is talk to an attorney who understands estate planning and talk through, well, is there a better way to set up my estate plan so that there is not a probate? Probate is where the will is filed with a court. In Washington, it's a really simple process, but it does involve the court and it does involve legal fees. Frankly, unless you do your own estate plan, your own estate planning documents yourself, online or free or with low cost, there are going to be fees associated with it. I understand that, and that's what keeps a lot of people from doing things. Plus, it seems like it's overwhelming. One of my goals with talking with you today is to try to make it not so overwhelming. That way people can say, oh, well, I think I can take some action to kind of resolve this nagging thought I have about, I don't have an estate plan, or I didn't think I need one, but I guess I do need them. Or, you know, mine is 20 years old and maybe you should have it looked at. Yes, that's my goal, is that you really, you know, look straight on at what your situation is and what steps you could take. They're not that difficult, but it's up to you to take those first steps. So a will typically will need a probate unless it's set up to not need a probate. A will with asset protection is something that is really important for a lot of our clients. In our state, in Washington, the only way for a spouse to protect money for the surviving spouse is if they do it through a will that has a particular kind of asset protection trust in it. You can't do that through a revocable living trust or through avoiding probate. So in that situation, is probate good or bad? Well, let's say you have a $600,000 estate, you and your spouse. Don't get caught up on the number. 600 is just easy to divide by 2. So if you have a $600,000 estate, the first spouse dies, wouldn't it be nice to protect $300,000, that first spouse's share, in a trust for the surviving spouse, so that if that surviving spouse needs long-term care, nursing home care, or, you know, remarries or whatever happens, that first $300,000 of the deceased spouse will never be subject to loss through creditors, through long-term care costs, through redirection to a new spouse. I mean, there's all sorts of reasons that you might want to make sure that you have an asset protection trust in your will, which means probate. So let me take a look here. I've got a question going back to durable powers of attorney. Dad has a general durable power of attorney for his wife. The wife has dementia, and he has made the daughter the agent for his durable power of attorney. Good. Sounds like good estate planning so far. Daughter wants to know, does she have the ability to do things regarding his wife or not? This is such a good question. So you have the ability to do things for your dad. Your dad has things to do, ability to do things for his wife, who has dementia. as a lawyer, what we would look at is, okay, what does the wife's durable power of attorney say? Did it appoint her husband? Yes. Okay. Does her husband then, under that power of attorney, have the ability to delegate things to somebody else? So there is an opportunity to delegate. So maybe dad is simply delegating to you things that he wants you to do on his, in his place for his wife. So the answer is maybe you do have the ability to transact business on behalf of the wife through the dad's ability to delegate to you. Another thing that I would look at is, does the power of attorney say, the wife's attorney, durable power of attorney, does it say, if dad can't act, then somebody else can act? Because if dad doesn't want to act, he can then decline to serve, and then the next named power of attorney in fact, same thing, steps up and they can act. So to answer your question with any degree of certainty or confidence, really need to review both of those durable powers of attorney to see what they say. A really, really good question. All right, I talked about a will. We're going to now talk about a revocable living trust. Everybody, I'm sure, has heard that term, revocable living trust. One of the things that I want you to know about estate planning is you hear the term trust a lot in different ways. When we say, well, who should you appoint under your power of attorney? I say, appoint somebody you trust. I'm not using that term in the way of revocable living trust. So that's confusing. When you hear the term trust, you'll hear revocable living trust, you'll hear irrevocable trust, you'll hear testamentary trust, you'll hear special needs trust, supplemental needs trust, asset protection trust, Medicaid gifting trust. So all of these terms mean something different. And that is why when somebody says trust, that's just like, okay, let's ask more questions. What kind of a trust is it? And frankly, most people don't even know what kind of trust it is, and they don't know what it says or how to administer it. So let's kind of step back a moment. Revocable living trust, what is it? It is a trust. Okay, what's a trust? A trust is a legal document that is signed that says that this legal fiction, so to speak, can manage assets through its trustee. So let me give you an example. Let's say I create a revocable trust. I am the grantor or the trustor. I'm the one who signed the document. Well, I want to be the trustee because I want to manage my own money until I can't. So I am the trustee. And guess what? It's all for my benefit. So I am the beneficiary. I wear all hats when it comes to a revocable living trust. And if I change my mind for whatever reason, I can say, I don't want this trust anymore, and it goes away. So that's one reason for confusion. Why did you have this trust in the first place? The reason that you had this trust was because you said, I want to avoid probate. A revocable living trust, if done right, will avoid probate. So I want to avoid probate. I want to make sure that my house goes to my kids and they don't have to do a probate. Okay, so I set up the revocable living trust. I need to do a deed where I transfer the title of my house from me to the trustee, who is me, so me as trustee. And then on my death, my house then goes to my kids because they're now the next beneficiaries of the trust, and one or both of them will be the trustee, so they can sell the house or do whatever they want with the house, all without the need to go to a lawyer or to do a probate. And so people really like this idea because they can do it themselves. And that's where people get into trouble, because when you try to do legal stuff yourself, you don't understand what you don't understand, don't know what you don't know, and you can get into problems with it. Revocable living trusts, I would say more often than not, when clients bring them in, it's clear that they didn't understand it or what the consequences are of doing it or how somebody would administer it after them or when they're gone. And so basically they were told, hey, this is your end all solution, just get a revocable living trust. They do that. They can, get them fairly inexpensively, either themselves or, $1,500 to $2,500 or so for the trust. And they feel like, okay, this is cheap, this is good. And they don't get any legal counsel or legal advice, and they don't know what is going to go on with the trust. So that's one of the problems. I do want to point out, as you can see on my screen here, that in Washington, revocable living trusts provide no asset protection for a surviving spouse. So if you wanted to make sure that when you go, your spouse can have money and it won't all be spent on a new spouse or on creditors or, financial exploitation or some kid, twisting his or her arm, or more importantly, long-term care. We see this a lot. You're likely not going to want to use a revocable living trust type platform for your estate plan. And by the way, if you do have a revocable living trust, you know that you also have what's called a pour over will. What is a pour over will? Why is it called that? A pour over will is intended to capture all the assets that you forgot to put in your trust because you didn't know and the lawyer didn't help you, or they helped you way back when, but 10 years have gone by, you opened up a new bank account or you bought a new house, you didn't put it in the trust. So the pour over will means that on your death, there will be a trust administration, but first there'll be a probate to capture all the assets you didn't put in the trust that you should have. They'll go through probate and they will pour over into your trust. So basically you tried to avoid probate, but you ended up having a probate plus a trust administration. So revocable living trusts, don't get me wrong, they serve their purpose and can be a very good estate planning tool. But I think more so with a revocable living trust than any other kind of estate planning type platform you have to understand it. You have to understand what you need to do with it, what you're giving up, how it works, and involve those people who will be the successor trustees. And I would say, talk to a lawyer when you don't know what you're supposed to do. You should be able to go back to that attorney that helped you with that revocable living trust, and you should expect responsive, helpful action. Will they charge you? Probably. I mean, that is the trade of attorneys, is that we charge for our advice, for our time, for our services. And that's one of the reasons people don't want to go back to lawyers. But if you want it to work correctly, go back to the attorney that drafted it and expect that they will help you, because that is what they should be doing, in my opinion. All right, so I did kind of already talk about this. What is a probate? Probate is, when the will is filed with the court appoints someone, your executor, your personal representative, to transact the business of your estate, to set up a trust if that's what's going to happen, to sell the house, to do whatever has to be done. Keep in mind that in Washington and in Idaho, probates are very, I'll say simple, but I'm saying that from a lawyer's perspective. From a layperson's perspective, there's a lot of statutory requirements and notice requirements and things that you have to do right. So maybe it's not fair to call it simple. It could be, if I was a layperson, I'd probably call it complicated, frankly. But from a legal perspective, it's you do this, you do that, you do this, you do that, you do this, and it goes smoothly. You get rid of any creditors' claims, and things are done as they should be done. Yes, they're legal fees. But probate sometimes is the only way to achieve certain results, like protect assets for your spouse against long-term care costs. Sometimes it's the best way to set up a special needs trust for a child who's on government benefits. There's other ways to do that, but I think the simplest way really is to do it through your will, through a probate. So oftentimes we really get pushback from clients. I don't want probate, I don't want probate. And I think once they understand, well, this is what the benefits will be. And frankly, there are costs of that. People say, well, what should it cost? You'll find lawyers who'll say, oh, I'll charge you $1,500 or $2,500. maybe they can do it for that. Frankly, that's very much on the low end, but it certainly isn't like California when you're paying 50 or 100,000. So you're going to be paying less than that, probably take a zero off of each of those. But there are legal fees. But let me go back to that client that I talked about a little while ago. They have 600,000. They want to create an asset protection trust for their spouse against long-term care costs. They have to go through a probate when the first spouse dies to put 300,000 in the trust. Let's say it costs them 7,500, which is kind of a middle of the road number for what probates typically cost. Is it worth 7,500 to protect 300,000? That's a question that I can't answer, but each person has to answer for themselves. Average cost to have wills done is in the chat. Again, you will get people that will quote, 1,500 to 2,500. Typically, what you should expect to pay for a full estate plan and not just wills, because any attorney worth their salt, unless there's a really good reason, they're not just going to do a will. They're going to do the most important documents, which are your powers of attorney, your healthcare directive, your wills, and other things that are just kind of ancillary to all the services an estate planning lawyer provides, in addition to their counsel. You can expect to pay, 35, 55. We've seen clients come in that have been quoted, 12,500. If you have a taxable estate, maybe you should be paying, 15 or 20,000. Maybe that'll save you hundreds of thousands in taxes. But what I want you to know is that prices will range. There's an old saying, you get what you pay for, but sometimes, people charge more than, what surprises me. And more often than not, people charge a lot less, but they don't provide much in the way of services. So, it's a fair question. When you go in and you do a consultation and you meet with a lawyer or meet with somebody who works at the law office, you should be able to say, what can I expect to pay? And a lot of places charge flat fees. Flat fees are to give certainty to, hey, what is this going to cost? One of the reasons that people don't like lawyers' fees is that, they're a high hourly rate. And that means hour after hour after hour, minute after minute, every time you talk to them, you're going to be charged. Sometimes that's necessary for matters that are, you don't know with any degree of certainty. Is it going to be easy? Is it going to be only 4 or 5 hours, or is it going to be 50 hours? You don't get flat fee quotes on those kind of cases, but a lot of lawyers quote flat fees for estate planning. So that's a really good question. This is important if maybe you don't have a minor child, but maybe your kids do. Maybe you have grandkids and they are the apple of your eye. I know mine are. Minor children need to be provided for, and they need to be provided for in a number of ways, in particular through the parent's will. Why is that? If both parents die in a car accident, for example, the child is now an orphan, the minor child. Who's going to raise that child? Well, you can bet that in many, many families, who will be the guardian is not clear. The court will appoint a guardian. The court has to. The child needs a guardian. Who do you want that guardian to be? If you are the parent, or maybe you're the grandparent, have a conversation with your kids about your grandkids. Who's going to be the guardian? You need to put that in a will. The will is what the court will take a look at, and they'll say, oh, look at the will. It says that instead of the aunt, Maddie or somebody, they want their friend Sue to be the guardian. Why is that? Because friend is really solid and is really responsible, and that's who the parent wants. But if the court looks at it, they might say, well, I'm not going to appoint a friend over a blood relative. Maybe the blood relative is really not the right person, but the court might appoint that person that you would not want. So for parents, for grandparents, really important that there be a will that nominates the guardian for the minor children. Of course, everybody hopes that this situation will never come up, With all estate planning, we hope that most of these situations won't come up. We know that death at some point, hopefully way down the road, we know it'll come up. We hope nothing else bad will. Estate planning, though, isn't about putting your head in the sand. It's about addressing the possibilities, putting protections in place. And then you've got it covered. Whatever happens, you're in good stead. All right, what else do you need to know? How often do I need to revise my estate plan? You need to revise your estate plan when anytime there's a significant change in your life, your health, your marital status, divorce status. Maybe a new child has come into your life. Maybe there's a grandchild now. Maybe you want a grandchildren's trust to be put in your will. Maybe you've inherited money from your parents. And by the way, if you're going to be inheriting money from your parents, and if you are anywhere close to a taxable estate in Washington, which is $2.193 million right now, and you might say, that's a lot of money. Look at the prices of houses. You know, it's amazing how housing prices have gone up, and they push people, many people who own a house, to a taxable estate level. Maybe you don't want to be inheriting to your own name a certain amount of money if that pushes you into a taxable estate level. So people don't like to talk to their parents. You know, I'm talking about, you're an adult, talk to your retiree parents, do so. They might not even be thinking about this. Maybe, you know, there'll be a good outcome if you talk with them. You'll find out, because estate planning isn't just about you. It's about this generation above you. It's about the generation below you and below you. It's really about typically family. If you're not in a family situation, it may be making sure that your friends or your charities are benefiting from whatever you have. So 5 years is a general rule about when you should review your estate plan. Sometimes you do it more frequently than that. Okay. I really think that this is one thing that people say, don't wait until it's too late, but it really has some significance. At ELG Estate Planning, part of what we do, a lot of what we do is we help retirees, we help seniors, we know government benefits, we help file Medicaid applications and get long-term care benefits. I can tell you it's much easier for us to help our clients if they don't have dementia. If they have dementia to the point where they don't have what's called legal capacity, we can't prepare for them new documents. What can we do for them? It's going to be really limited. So, you know, maybe you or a family member have a diagnosis of Alzheimer's. That doesn't mean it's too late, but you know, if you wait very long, the disease will progress and it will slowly take away somebody's ability to make their own decisions. And that's heartbreaking when that happens. And it's also very difficult for estate planning when that happens. So if you're thinking about it, or you know somebody who needs estate planning, really, you know, now's the time to take some action. Don't wait until it's too late. And it might not be from some dementia progressive process. Sometimes people become sick unexpectedly. They are in an accident. There's a heart attack. You know what, there's all sorts of things that can occur. So, all right. So what I want to make sure of is that I've answered all your questions. Put them in the chat box if you have any more questions. We're very happy to talk with you, to share any of our knowledge with you, to help any family members. I'm going to stop the share. Oh, before I do that, here's our contact information. Call us at 509-468-0551. Visit us at elgwa.com. We have offices in Kennewick and Spokane and Seattle. We would be very pleased to help you. For those of you that have stayed with us, in addition to getting this guidebook that I just went through, you are also going to be receiving from us a certificate that will entitle you to a complimentary consultation with us in the event that that you qualify for such a consultation. We are not the law firm for everyone. You know, no law firm is a law firm for everyone. Sometimes people call us and they really need assistance, but perhaps they don't have assets, or they don't have assets that we can help them protect. And depending on their situation, we direct them to free legal services. There are some very good free legal resources available to people. So we do want to make sure that we can help everyone who contacts us, even if it's not through our providing legal services. It could be through us helping you get to the right place. So again, I appreciate you spending your afternoon with me at the time that we had together. I wish everyone a happy fall. We've got gorgeous October weather. This is National Estate Planning Awareness Month. So we are going to be following up in a couple of weeks. And if you have any particular topics that you want, email us, webinar@elgwa.com, and let us know what you want to hear us talk about. So stay healthy, stay safe, everyone. Thanks again. I appreciate you being with me today.